If you understood what a fiduciary was, then you know that your lawyer cannot honestly and fairly represent your best interest and be an effective fiduciary to two different people on opposite sides of the table at the exact same time. And I know that there are some lawyers out there who might disagree with me, and guess what? I don't care.
There's someone you should know.
Hey everybody, welcome to the BOMB Podcast. BOMB stands for Business of Music Bootcamp, which means that this is the place where we will drill down on the business and legal aspects of the music industry. Everything from copyrights and contracts to policies and practices, whatever it takes to educate and empower you with the knowledge you need to make informed decisions about how to protect yourself and your music is what you'll find on the BOMB. I'm your host, Professor Butler, and as a retired entertainment attorney, former record label executive, music law professor, and college administrator, I have counseled thousands of artists and musicians on the intricacies of the music business. Now it's your turn.
The information in this podcast is not intended, nor should it be construed as legal advice. If you have questions of a legal nature, we strongly recommend that you contact an attorney in your local jurisdiction who specializes in music and/or entertainment law. For guidance, check out our website at professorbutler.com and sign up to receive a free resource on how to find the right lawyer for you. And now, your host of the BOMB Podcast, Professor Butler.
Hey everybody, and welcome to episode 5 of the BOMB Podcast. I can't believe we're at episode 5 already. This is so exciting for me, if you can't already tell. Why? Well, we're doing about 100 or so downloads a week, which is far more than I expected being a brand new podcaster. So thank you all for your support. Keep telling your friends and keep coming back. I have lots more business and legal aspects of the music industry information to share. So far, we've been talking about how not to get scammed, what to do if somebody steals your music, and what to do if someone steals your name. And if you listen to each episode from the very beginning, you'll hear a very brief disclaimer in the introduction read by one of my music business management students at Berklee College of Music, the incomparable Miss Sarah Fine. And each week, Sarah reminds you that what you hear on this podcast is not intended to be legal advice. Now, the reason I and others that you might listen to share this disclaimer is because of some of what I'll be discussing throughout this episode. Sarah also says that if you're interested in legal advice, you need to contact an attorney in your local jurisdiction who specializes in music and/or entertainment law. Now, I can talk to you all day about how to find such a lawyer, and I think I'll do so next week. But before you even start looking for a lawyer, it is really, really, really important that you understand 3 things. Number 1, exactly what is it a lawyer does? Number 2, exactly why it is that a lawyer is obligated to do what they do. And number 3, what are the 4 things you should expect your lawyer to do for you at all times? In this week's episode, I'll be breaking down that subject using an email I received a long time ago, as well as from a recent story in the news. So first the email, and it goes a little something like this. Dear Professor Butler, I am an independent artist who, after releasing and finding pretty good success with my first album, has attracted the attention of a major independent record label. The label recently offered me a recording contract, which I am very eager to sign. I know I should hire a lawyer, but I just can't afford one right now. Fortunately, the label has graciously recommended that I use its lawyer, who has even agreed not to charge me any money up front. This sounds like such a great opportunity that I would hate to pass it up. Now here comes the question. What if my label's lawyer is my lawyer too? Does it really make a difference? Sincerely, Thirsty. And by the way, if you go back to episode number 1, you'll discover that thirsty is more than just a name. It's a very unhealthy and unproductive state of mind. So today we're going with thirsty. So who is our thirsty? Our thirsty is an indie artist who, after experiencing his first taste of music industry success, is approached by a major independent record label. This is exciting news. It's an exciting time for thirsty, especially if securing a record deal is one of his lifelong career objectives. And for some people, for whatever reason, it still is. Thirsty, just like all of us, however, has heard plenty of stories about people getting ripped off by their record company. So at least he recognizes the importance of having legal representation. What he doesn't recognize, probably because no one ever told him before now, is that adequate legal representation is an investment. It costs money to hire a good lawyer, and sometimes you get what you pay for. Now, don't get me twisted. I'm not saying that a free lawyer is no good, or that the more expensive the representation, the better. Some of the best lawyers in the world do what we call pro bono or free work, while there are any number of expensive lawyers that probably suck. But just like everyone else on your team and everyone you do business with, they must be screened and vetted to make sure that you're getting exactly what you bargained for. That's why I don't want to share any information yet on where to look for a good lawyer, right? I'm going to save that for next week. Instead, I decided to focus on what a lawyer does and what they're obligated to do. Once you and Thirsty know what legal representation should look like, then by all means, start looking for a lawyer. And don't worry, I'll provide plenty of information on the how and the where to find the right lawyer for you. But for now, let's just start with number 1 on my list of things you need to understand, which is, what exactly is it that a lawyer does? And before I jump into it, real quick, I want to clear up any confusion regarding the difference between a lawyer and an attorney. The terms are used interchangeably almost everywhere, including in this podcast. They are used interchangeably because for most of us, there is no real difference between the two. They do the same things, they serve the same purpose. So when you say I'm going to hire a lawyer or I'm going to hire an attorney, basically same thing, same person. However, if you want to get picky about it, a lawyer is someone who has studied and is trained in the law. A law student who has graduated with a JD degree, also known as a Juris Doctorate, also known as a Doctor of Jurisprudence, is technically a lawyer, right? Because they studied and are trained in the law, but they can't call themselves or hold themselves out as lawyers until they take and pass a bar exam in their particular jurisdiction. Once they've done that, they can start to practice law by providing legal representation. Now, an attorney, also known as an attorney at law, is basically a lawyer, right, who has studied and is trained in the law, who is also qualified and authorized to appear, prosecute, and defend actions in court. So lawyers can't go to court, attorneys can. And although the terms often operate as synonyms, an attorney is always a lawyer, but a lawyer is not necessarily an attorney. For our purposes, though, they can both represent you, but only attorneys can represent you in court. Historically, and to the American Bar Association, this distinction is a big deal, but to the general public and for us, they do the same thing. It doesn't matter. And sometimes I just use them interchangeably depending on which word sounds best in the sentence, right? Okay, so with all that out of the way, exactly what is it that lawyers or attorneys do? Well, lawyers can provide all sorts of services. They can select, draft, or complete forms, agreements, or other legal documents that affect your rights. They can negotiate legal rights and responsibilities on your behalf. Some of them can represent you in court, but all of them can speculate a particular outcome based on the circumstances of your case and offer a specific course of action. No matter what a lawyer does, everything they do relates to one thing above everything else. Lawyers give legal advice. That's the one thing that they do that differentiates them from every other member on your team. So, what constitutes legal advice? Well, according to findlaw.com, legal advice refers to the written or oral counsel about a legal matter that would affect the rights and responsibilities of the person receiving the advice. Legal advice requires careful analysis of the law as it applies to a person's specific situation, as opposed to speculation based on generic facts. In other words, if someone advises you on what you should or should not do as it pertains to your specific situation in a way that could affect your legal rights and responsibilities, that's what the law considers to be legal advice. Now, there's a big difference between giving legal advice, which is what I used to do because I am retired, versus dispensing legal information, which is what I do now. I also dispense legal education as a professor and a chair. Any non-lawyer can give out legal information. Legal information is factual, it's generic, and it does not address any specific set of circumstances. Now, the key word here is generic. Legal information is generic in that it lacks the details and specifics of your particular situation, which means when you obtain legal information from free online legal websites or podcasts such as this one, social media, newspapers, magazines, online message boards, how-to guides, self-help forums, whatever, up to and including advice from family and friends, that information that you receive is much too generalized in nature to be considered legal advice. Legal advice is specific, direct, and proposes a course of action. Only a licensed lawyer or practicing attorney, just using the terms interchangeably, may legally give legal advice. And that's because legal advice requires that the person has to give the advice, or who has the advice has legal knowledge, skill, education, and judgment. The person giving the advice has to apply a specific area of law that they were trained in or that they studied to a particular set of circumstances. The advice has to affect your legal rights or responsibilities, right? So all of these things are what legal advice has to consist of. And the difference between legal advice and giving legal information is the difference between telling somebody what to do versus telling them how to do it. I can tell you all day long how to avoid paying your taxes. But as soon as I start telling you specifically not to pay your taxes, I have crossed the line between providing information and giving advice. There are also additional obligations on the part of the lawyer that arise from giving legal advice. The lawyer and the client either expressly or impliedly form what we call an attorney-client relationship, making the lawyer bound to certain rules, rights, and responsibilities. Which brings me to number 2 of the things you need to understand about lawyers before you start calling all over town to find one, which is what exactly is an attorney-client relationship and exactly what is the attorney obligated to do. An attorney-client relationship is formed when a lawyer agrees to provide legal assistance to someone seeking the lawyer's services. This means that there are 2 requirements to an attorney-client relationship. The first, someone has to seek advice. The second, someone has to agree to give the advice. That's simple, right? Wrong. Because depending on the situation, there could be a lot more to it. An attorney-client relationship may be formed expressly, using the exchange of money or a signed contract, or it may be formed impliedly without a fee or a signed agreement. For example, if a lawyer gives legal advice to someone seeking legal advice, right, there is no fee or contract involved, but the lawyer can reasonably foresee that the person will rely upon the advice, an attorney-client relationship is formed. Or if a potential client reasonably believes that she or he has been represented by the lawyer, an attorney-client relationship is formed. This is the reason why most lawyers and even non-lawyers are very careful when interacting with potential clients by letting them know that a mere consultation does not establish an attorney-client relationship. And even then, if you do happen to consult with an attorney without hiring them and you don't form either an express or an applied attorney-client relationship, the lawyer still has to assume some of the duties and responsibilities toward you as a prospective client. Specifically, any information that you share with the lawyer that has anything to do with your legal circumstances at the time cannot be revealed and may not be used against you at a later time. So you can consult with a lawyer and not necessarily hire them, and they still have to protect your interest in regards to the information you shared. All right, so if you'd like more information about this particular subject, LegalZoom.com has a great article called Attorney-Client Relationship 101, which outlines and provides a nice list of things that an attorney is obligated under the law to do for their clients. When it comes to our thirsty, he at least recognizes that he needs legal advice in regards to the recording contract that he just received, and is, or at least will be, actively seeking the advice of legal counsel, which means he's ready to first consult with an attorney, then hopefully enter into an attorney-client relationship where the attorney will then give him legal advice and represent his best interest. All he needs is an attorney willing to accept him as a client based on the details of his circumstances and the lawyer's area of expertise, which is hopefully music. But before Thirsty starts looking for a lawyer and worrying about what the lawyer should be doing for him, it's really important that he and you understand why lawyers are obligated to do the things they do. When you seek advice or representation from a lawyer, the lawyer is bound by strict standards of professional responsibility. In order to understand fully the level of professional responsibility that lawyers must adhere to, you really have to understand the word fiduciary. A fiduciary is a legal term describing a relationship of trust, confidence, and reliance between two parties that obligates one party to act solely in the interest of the other party. There are different types of fiduciary relationships. However, the attorney-client relationship is one of the most stringent of all fiduciary relationships. The United States Supreme Court says that the highest level of trust and confidence must exist between an attorney and his or her client, and that an attorney as fiduciary must act in complete fairness, loyalty, and fidelity in dealing with clients. And think about why this is. You need to be able to trust this person with your most private information and sometimes your deepest, darkest secrets. You may be in a position where you are trusting them with your rights, your money, your liberty, and even your life. That's why all lawyers are fiduciaries, which is to say that they owe a fiduciary duty to their clients. So what is a fiduciary duty? Well, a fiduciary duty is the duty of an agent, or in our case, an attorney, to treat his or her client with the utmost candor, care, loyalty, and good faith. Basically, to treat the client as well as the attorney would treat themselves. All attorneys have a fiduciary duty to their clients to act in their client's best interest and to put their client's interest above even their own interest. This is the essence of the fiduciary duty, for your lawyer to put your interest above all others, including his or her own interests. Which brings me to the third thing you need to understand before you start looking for a lawyer. What are the main things that you should expect your lawyer to do for you always? These are the elements of the fiduciary duty, and they can be described using what Chron.com calls the 4 C's competence, communication, confidentiality, and conflict avoidance. Basically, you should expect your lawyer to be competent. Attorneys have a fiduciary duty to use their legal knowledge, skill, and training to represent you competently, zealously, and within the bounds of the law. They must approach their work with all of the thoroughness and preparation necessary to protect your interest. You should also expect your lawyer to effectively communicate with you. Attorneys have a fiduciary duty to communicate with you in a timely and effective manner. They have to keep you informed of developments in your case. They have to obtain your approval before agreeing to a settlement or other resolution of your case. And they have to provide you with enough information to allow you to make a good decision about how to proceed. You should expect your lawyer to maintain confidentiality. Confidentiality and trust are essential to a fiduciary relationship. Unless you give your attorney permission to disclose what you've shared with them, they cannot reveal confidential information either about you or any information that you have told them or shared with them. Any conversation between you and your attorney is kept confidential, except in very, very few, very specific and rare occasions where either your life or the life of somebody else is in danger. And finally, what you should expect your attorney to do is to avoid conflict. Avoiding conflicts of interest is the cornerstone of a lawyer's fiduciary duty. If your lawyer represents you in a business matter, then decides to take on another client with opposing interests, your lawyer may be breaching their fiduciary duty. And the opposite applies. If they're representing somebody else, like in Thirsty's case, the record label, then they take you on as a client as well regarding the exact same matter, which in Thirsty's case is the record contract, then a conflict of interest exists. Even the appearance of a conflict can cause significant problems for you and your lawyer. Case in point, the Migos. So a story broke in Variety last week and was republished in Rolling Stone, Billboard, Hollywood Reporter, all the music and entertainment blogs. And the story reported that the Atlanta-based rap group Migos filed a complaint against their attorney, claiming that he abused his position of trust as the group's fiduciary from the moment he was retained as their lawyer. And it alleges that the lawyer cheated the group out of millions of dollars, accusing him of glaring conflicts of interest and of favoring the group's record label, Quality Control, which he also represented. The suit, which does not specify an exact amount of money beyond millions of dollars, accuses the attorney of professional malpractice and unjust enrichment, among other claims. In the malpractice lawsuit filed by the Migos, the trio alleges that their attorney abused his position of trust, citing that he created one-sided deals that benefited the label, which they referred to as the lawyer's highest or higher priority client. So in other words, they were saying that the lawyer represented them and the label, and that the label is the higher priority client. The group also claims that unbeknownst to them, that they didn't know that their lawyer's representation of the label created an incurable conflict of interest, that the lawyer's primary loyalty was to the record company. Now, I read this to mean two different things. When it says unbeknownst to them, that means either they didn't know about the conflict or they didn't know the extent of the conflict. So it could be either or. Either way, how does something like this happen? How do you and Thirsty keep it from happening to you? Well, first of all, you have to know It happens all the time. And it happens all the time for two reasons. Reason number one, you, like Thirsty, don't already have your own lawyer. Look, I know you're a musician, you're doing your own thing, you're making and releasing music independently, you're having a great time, you're spending all your money in the studio. I get it, right? You're not thinking about hiring a lawyer because at this particular point in time, you don't need one. I get that. And if you're one of those artists whose lifelong dream is to be signed to a record label, when a record label comes along, right, you feel as if it's a dream come true. Unfortunately, when it comes time to negotiate that deal, you do not already have an attorney on deck to represent you, nor do you know of any lawyers, nor do you know of anyone that knows any lawyers. Okay? So what do? Well, you ask your label if they know any lawyers. And of course they do. They do because they deal with and work with lawyers on a daily basis. So what do? They refer you to a lawyer, either a lawyer that they've worked with, right? It has to be somebody that they know, right? So it's either somebody that they've worked with in the past, or it could be somebody that they are currently working with right now, today. And herein lies the problem. Whether it's someone that the label has worked with in the past or is currently working with, that lawyer has a pre-existing relationship with the label that, in all honesty, they do not want to fuck up. There, I said it. The lawyer does not want to do anything that could jeopardize working with the label in the future. Why? Because the label pays good money and they generally pay on time. So what's a well-meaning attorney to do, right? What they have you do is, if you're approached by an attorney that is representing the label and they want to represent you as well because you want them to, they'll have you sign something called a conflict of interest waiver. By signing the waiver, you acknowledge that the lawyer told you about the conflict. They told you that they also represented the label. And they may have even told you, which could be the issue in the Migos case, that the label's interest may be in direct opposition to your interest. And when you sign that waiver, you agree to waive that conflict of interest so that the lawyer that represents the label can represent you too. Now, I know what you're thinking. Who would be nutty enough to sign such a form, waiving the existence of a conflict of interest between them and their opponent? I'll tell you who. Somebody who does not know reason number two for why this happens all the time. Someone who does not know or fully understand what I just explained to you about the fiduciary responsibilities of an attorney to his or her client. If you understood what a fiduciary was, then you'd know that your lawyer cannot honestly and fairly represent your best interest and be an effective fiduciary to two people on opposite sides of the table at the exact same time. And I know there are some lawyers out there who might disagree with me, and guess what? I don't care. Because remember what I said about a fiduciary? Remember the words I used? How can I, let's say I'm the lawyer, how can I use trust, confidence, reliance, candor, care, loyalty, and good faith in protecting your interests, and then use the same amount of trust, confidence, reliance, candor, care, loyalty, and good faith in protecting the record label's interests, whose interests are not only different from yours, but are often in complete opposition to yours? And the answer is, I can't. I can't. If I'm keeping your secrets, which have to do with your rights and responsibilities to the label, but I'm also keeping the label's secrets, which have to do with their rights and responsibilities to you, how do I reconcile the two? How do I keep them separate or keep either side's secrets from influencing my advice or my perspective? In my humblest of opinions, I can't. No lawyer can. And when avoiding conflicts is part of a lawyer's foremost fiduciary responsibility to their client, how can they in good conscience have you sign a piece of paper that waives the very thing that they are obligated to do? Now, for argument's sake, am I saying that there can never be adequate legal representation where a conflict exists? The answer is no. I never say never. I'm sure there are plenty of amicable relationships or simple disputes where having the same lawyer might not be a big deal. I'm just saying, when the party has interest in opposition to your interest, it's not a good idea. I just don't like it. I don't like it when your lawyer represents you and your label, or when they represent you and your producer, or when they represent you and your manager, or when they represent you and anybody else on your team. How can your lawyer look out for and place your best interest at the forefront when he or she is doing the exact same thing for the people that you might have issues with? And that is what I believed happened to Migos. If it's true that their attorney was also their label's attorney, and they didn't either know about the conflict, they didn't expressly waive the conflict via a written agreement, or that they did not know the extent of the conflict, then they very well may have a case. Oh, and by the way, the Migos case was filed in the state of Georgia. Each state has its own ethical rules for lawyers, called the Rules of Professional Conduct. In some states, it's called the Rules of Professional Responsibility. And when lawyers fail to live up to this code of conduct, or they violate these rules of responsibility, they face either a legal malpractice suit, like the one filed by the Migos, or disciplinary action by the state board, which can take action against them, imposing everything from a simple warning, slap on the wrist, all the way up to disbarment, which means they lose their license to practice forever. And if your lawyer's actions were also illegal on top of violating the code of conduct, he or she can be criminally prosecuted. As for what I told Thirsty, I suggested that he avoid the labels lawyer like the plague. I did not chastise him for not knowing any lawyers or already having a lawyer on deck, but I did refer him to a variety of resources that we don't have time for today, but I'd be happy to share in next week's episode. So, what have we learned this week? Wow. First and foremost, we learned that a lawyer's job is to give legal advice, and only licensed practicing attorneys are authorized to do so. All others are restricted to providing legal information. We also learned that the attorney-client relationship is based on trust, confidence, and is sacred in the eyes of the law. It creates a fiduciary duty on the part of the lawyer to competently communicate, keep those communications confidential, and to, above all, avoid conflicts of interest. All right, that is it for episode number 5 of the Bomb Podcast. I pray that you are having as good a time as I am, and that you are learning as much as you can, and that you are feeling empowered. Take care of yourself, and I will see you next week. Thanks for joining me on the Bomb Podcast. If you were educated, empowered, or inspired by what you heard, please subscribe today to be the first to receive the latest episode. And don't forget, post a review, tell a friend, follow me on social media, and join my tribe at ProfessorButler.com.